Before I touch on the transition issues, I just want to address some of the points that were raised earlier this afternoon to help provide perhaps a little bit more of a complete answer. Craig raised the issue about brokers, and one of the important issues for consumers in this province, given the fact that fewer than 3% of consumers actually buy optional coverage now, is the education piece. What are consumers going to be told, and how is the message going to be taken to consumers by brokers? And of course, some policies are written directly by insurers and not by brokers. The Insurance Brokers Association of Ontario is very busy right now educating brokers across the province of Ontario. I think they've set up something in the order of about 50 seminars to be held across the province to educate brokers on what they're supposed to do. A working group of the Reform Implementation Committee is currently underway in preparing the kind of disclosure information that the public requires in order to make informed decisions about what kind of coverage they should have. So certainly the brokers, I think, are very busy. They understand their obligation to inform consumers about what their rights are, because one of the risks that the brokers face, of course, is liability in failing to do so, and that is an issue that's going to come up. So I just wanted to address the brokers issue. I also wanted to touch on this notion of insurer or insurance adjuster discretion. You will, and I just want to clear it up, you will know that under the current SABS, that when an adjuster wants to deny a benefit that a Section 42 examination is mandatory, they have to send it out for an independent, or I never call it independent, I don't know why I said that, insurance examination. But in any event, that under the new SABS, they will not be mandatory. There will be insurer discretion. What I wanted to point out to you, though, is that there must be medical and other reasons why they're not doing the examination. In the event that an insurance adjuster opts not to do an insurer examination, he or she does so at their peril, because they have to present sufficient justification to deny the benefit, and ultimately what they have to be thinking about is what they're going to be facing in the event that the matter proceeds to arbitration or court. There's the potential for a bad faith claim if they have exercised their judgment improperly in denying the benefit. And I think by default what you will see is, in spite of the introduction of discretion, that you will see many IEs in connection with denials, perhaps not as many as before, which is a good thing, but still a great number of IEs, because insurance adjusters don't want to risk a bad faith claim against them. What might happen is they may be able to rely on old reports or existing reports to deny benefits, but there has to be medical and other reasons. And finally, with respect to accessing services other than when money runs out through things like CCAC or the Ministry of Health, the fact is that the Ministry of Health is the first payer right now. They pay first before you access accident benefits. Whether there is some room to access CCAC or other things through the community when you fall in this gap, I think remains to be seen. So that's just a couple of comments about issues that had come up, and we'll have more opportunity to discuss this during the panel discussion. So what are we talking about? When we talk about transition, we're talking about moving from the current system to the new system. We're talking about a number of different scenarios. Number one, we're talking about accidents that occur before September the 1st, which I'll refer to as old accidents. Old accidents that occur before September the 1st are likely to give rise to claims for benefits after September the 1st. What we want to know is what happens with cases that predate the new SABS when benefits are paid after the new SABS. We also want to know what happens with old policies and new accidents. So what we're talking about there is a policy that's in effect September the 1st and before, but where the renewal date doesn't come up until after the new SABS comes in. That's important. And then new policy, new accident is pretty straightforward. I don't think we have to really talk about that stuff. So what are we talking about? I think we have to put it in perspective. And when I talk about perspective, I want to talk about a couple of things. The first is we need to have a principled approach to what we do when we move from old to new. And when I talk about a principled approach, what I'm saying is that the event that triggers entitlement, we all know, is the happening of an injury in an accident. That triggers entitlement. At that point, the notion is that the rights of the injured party crystallizes at that point, no matter when the new regs come in. And generally speaking, you'll find, with a couple of exceptions, I think, that in the transition, rights that have been triggered before September 1st survive September 1st, generally speaking, with some exceptions which make no sense, but we'll talk about. But really, it makes common sense that if the event that gives rise to entitlement has happened, that entitlement ought not to change. Now, on the same theory, arguably, if you bought a contract before September the 1st, how come your contract is being revised retrospectively? I can't help you with that one, but that's what's going to happen. And that happens by operation of Regulation 3510, which you'll find in your material, I think is at tab 9A. So we have to start our look at transition by talking about Regulation 3510, which essentially takes the current SABs and amends them. And the way it amends the current SABs is it simply says that no amount referred to in the old SABs, even though the current SABs are going to call old SABs, no amount referred to in the old SABs is payable under the new. So your limits. And what essentially happens is that, for example, the $100,000 med rehab non-cat limit under the old SABs disappears in your policy, in your existing policy, as of September 1st, 2010. But to make the matter confusing, even though those amounts disappear, the amounts payable under the new SABs are determined under the old. Is that perfectly clear to everybody? Okay, so the limits are changed, but the amounts are still determined under the old SABs. I'm going to talk about what that means, with one exception, and that is that assessment costs are clearly new SABs. So old accident, ongoing entitlement to benefit, new limits on assessment costs. Section 424 disappeared, gone, okay? And $2,000 cap on assessment and examination costs exist for old accidents after September 1st, 2010. That much is pretty clear. Procedure, after August 31st, new procedure applies to old claims, fundamentally. So after we look at 3510, which is the provision that amends old SABs to take out the limits, we then have to look at Regulation 3410, which is the new SABs, and you'll find that at tab 9 of your material. If you look at 3410, Section 22 and Section 68 will provide you with the essentials you need to know about transition from old to new. Section 22 in Regulation 3410 essentially repeats what Regulation 3510 did to the old SABs, fundamentally, although there's one section there that I don't understand, so I won't even talk about. And then, again, it makes the exception that examination costs, so Section 24 examinations, are gone, and that the new limits are the limits under the new SABs. Now, so what happens is 3510 now has taken away the limits under the old SABs, and Section 68 has now replaced those limits with essentially the optional coverage under the new SABs. So we had $100,000 non-cat limits under the old. The reg has eliminated that and substituted for that a deemed optional benefit under the new SABs. And the deemed optional benefit, if we take med rehab as an example, you'll find in Section 2813. Now, that optional benefit is the $100,000. Okay, so if you have a policy that doesn't renew until after September 1st, your $100,000 med rehab under old SABs disappears, and for that you substitute the new optional limit $100,000 under the new SABs. That's essentially what happens. Okay? The same thing happens with respect to caregiver, housekeeping, and homemaking. So for caregiver, housekeeping, and homemaking, under the old SABs, the regulation makes that disappear after September 1st, and it's replaced by the optional coverage under Section 28(1)(2). What that essentially does is that for all drivers who renew their policy after September 1st, the optional coverage essentially preserves the limits that they had under the old policy until the old policy lapses. And when the old policy lapses, you're into the new, and that's it. Okay, it's gone. So presumably within 12 months of September 1st, we'll all be on the new regime. If you had optional coverage, though, under your old policy, and you bought more than, so you bought $1 million med rehab for non-cat as an example, or you bought enhanced IRB or whatever you bought, all those optional coverages will continue until the policy lapses. So what happens with incurred, the issue is amount determined. So the new policy says that your benefit or the amount of benefit you get will be determined under the old SABS. And the words are amount determined. And the issue, what does amount determined mean? Does it mean something more than just calculating mathematically how much your benefit is? Does it go to an issue of entitlement? Because if it goes to an issue of entitlement, then we get into this issue about incurred expense, as Craig talked about in his talk. Does incurred apply on the old policy for an old accident for a benefit payable after August 31st? That's the issue. And it affects everything: attendant care, housekeeping, caregiver, medical. And what I have interpreted the section to mean is that the new definition of incurred under the new SABS will not apply to an old accident, old policy, but a benefit payable after August 31st. So let me say that again to make it clear. If you have an accident before September 1st, and you were receiving, for example, an attendant care benefit or attendant care provided by mother to child, and mother was not a wage earner at the time, and the entitlement to attendant care carries on past August 31st, mother will be entitled to receive the attendant care benefit on the same basis that she got it before, because the new incurred doesn't apply to her. And the reason is, logically, that that amount determined ought to mean something more than just a calculation of the mathematical amount, but also the issue of entitlement. How do I know this? Well, I don't know it for sure, except that we have asked FSCO about what their interpretation is of this section, and we've had long discussions, certainly at our office, about what it should mean and what interpretation it's capable of meaning. And FSCO, I think, agrees with our conclusion that that the new definition of incurred is not going to upset ongoing claims for benefits for old accidents. And that really only makes, I think, common sense and is fair. So I think that's what we're looking into when it comes to incurred. Old incurred applies, and FSCO agrees. Do assessment costs for old accidents reduce limits after August 31st? So this is another interesting issue. You see, if the old limits are eliminated under the old SABS and replaced by the optional coverage under the new SABS, the issue for us is when I get an assessment done under the new SABS, which I know is limited to $2,000, even though it's an old act, will that assessment cost come off my limits? This, I think, is less clear, because the effect of the amendments is to essentially alter my old policy by removing my limits and replacing it with optional coverage under the new SABS. It's arguable that the assessment cost should come off the limits, but it is inconsistent with a principled approach to this, which is the event that crystallized my entitlement already happened. It ought not to change retrospectively. So what I'm saying here is I think that this is a matter that's open to interpretation. I believe, on my interpretation, that the assessment costs done after August 31st will not reduce the amount of benefit available to an injured person after August 31st. And again, FSCO agrees with that interpretation. We've run that by them, and they agree with that interpretation. Another issue, and this isn't strictly a transition issue, the issue is attendant care payable for a minor injury not subject to the $3,500 limit due to a pre-existing injury? So the question is the escape clause from minor injury. As we heard from David Payne, you can, if you can establish that by virtue of a pre-existing injury, the $3,500 doesn't meet your needs, then you can get out of the $3,500. What that means is that you will get access to up to $50,000 in medical and rehabilitation benefits if you can show this pre-existing condition is the problem. David raised issues about causation, which is going to be a problem, because, and I would like to add to his caution, I think he cautioned you that we have to be careful about what we call these things when we do we attribute the need for med rehab to the pre-existing condition or to the exacerbation of some pre-existing condition that gave rise to it. And that's a causation issue which we can talk about if people are interested in the panel. But in any event, because you're escaping the minor injury cap, the issue is, are you then therefore labeled a minor injury, and as such, even though you escape it, you still don't get attendant care? Because remember, if you're labeled minor injury, there's no attendant care. I think the answer to that question is, on a principled basis, you ought to get the attendant care. For the same reason that I've said earlier, the principled basis being that if you are considered, if by virtue of that clause, it's considered that $3,500 is simply insufficient in your circumstances to meet your needs, and therefore it's as though you were not in the minor injury category for all intents and purposes, why should you be denied attendant care, just on a principled basis? You're categorized as essentially non-CAT for the purpose of accessing $50,000 in med rehab. Why should there be any limit on attendant care? This is where I think the principled analysis has fallen apart. FSCO's interpretation, as I understand it, is that you are stuck and that you do not get attendant care if you have suffered a minor injury that you can escape from. So I suspect you don't get attendant care. In terms of transition, again, any reference in the old SABS to the pre-approved framework is considered the minor injury guideline now. Again, assessment cost limited to $2,000 applies to old accidents. And there is maybe not a minor thing for some people in the room, where what happens if you do an assessment before September 1st, but you invoice for your assessment on September 2nd? What's the basis for paying? Now, the way I read the SABS, I think you are at some risk if you don't invoice for your services before September 1st of being stuck with a cap, the way you read the section. There is some risk. This is, I think, a mistake. If you provide the service before, again, on a principled basis, there's absolutely no justification for not paying you based on the old rules. What if you did the assessment August 31st and you got the invoice out on September 1st? It's a bit of an absurd situation. I think that, having been intimately involved in this process, I think that there are a lot of problems with the SABS because basically they've been rushed through. This is a rush job. There are a lot of these gaps and mistakes, I think, that we're going to have to iron out. And hopefully what will happen is that FSCO will help us with some of this with clarifications through bulletins that they will issue that people will feel they're bound by, and that won't be a problem. So I'm hoping this isn't a problem for anybody. I'm hoping that all assessments and examinations done before September 1st are paid based on old rules.